My name is Mitchell Lee. I'm the student director for the competition. Thanks so much for joining us for the final round of the 2026 Halloum 1L negotiation competition. In a few moments, these 4 students will, in front of you, participate in a live 40-minute negotiation. On one side, we have Cole and Jack, and on the other side, we have Cameron and Kausar. A few things you can expect. With the 40-minute negotiation, the teams might take a short break to regather, strategize, confer. And afterwards, they will leave the room for 5 minutes before coming back for a post-negotiation analysis in front of the judges. The judges will then score them, provide some feedback for both teams, and today we will announce the winner of the competition. Before we get started, I just wanted to thank the judges, Clint, Rana, Grace, and Ellen Paige, who've very graciously offered their time in evaluating the students today. It's really the judges and the students together that make the magic happen, with the students bringing the fact patterns to life and the judges offering the feedback from the wealth of experience that they have. I also want to thank Joseph Halloum as well as the donor firms for making this competition happen every year and making it such a worthwhile experience for the 1Ls. So thanks again for being here today. We'll make sure to wrap up by 2 p.m. Yeah, feel free to get started. I'm just going to go take my seat.
You want to use a phone for a timer?
Yeah.
Yeah, I'll see
Are
that.
you getting your phone out?
Yeah. I'll just run a stopwatch.
Perfect.
Okay.
All right. So we are very excited to be here. I think that our collaboration over the last 18 months has shown how well our 2 teams work together and how much technical potential we have. So that being said, we want to be honest about why we're here. We don't see ourselves as buying a promise from you. We see ourselves as partners who both have skin in the game and are rewarded when the technology delivers on its potential. The reality is that QSecure's value today is largely prospective. Technical scalability hasn't been proven yet, and there's significant regulatory challenges. Because of that, we believe the right structure is one where consideration is tied to outcomes. We want to propose a framework where the deal is organized around clear, objective milestones, and we're happy to reward your team generously as we reach them. We'd like to start with a performance-based structure before we talk about headline numbers. We think getting the framework right will make the valuation conversation much more productive for both sides.
So to start, we kind of wanted to just put some our package offer on the board. Like Cam said, we'd really like to start with payment structure, moving into valuation, then indemnity, followed by non-compete. And so we wanted to start with a 25% upfront bonus. We think that this kind of encompasses the value that we see in QSecure, as well as providing you guys the ability to determine the earnout potential, and so no money is left on the table. And so we see this based off of 3 key milestones: regulatory clearance, customer adoption, and key personnel retention. And so essentially, with the 25% upfront, the other 75% would be determined by the milestones. Kind of leading into that, the valuation we see would be $100 million. We think that this encompasses the extreme potential that QSecure has, as well as takes into consideration the uncertainty around technical scalability, regulatory approval, which is pretty high concern for us, considering that there are a lot of concerns around regulations and how much approval we can get. For indemnification, we're looking at 50% of the deal value for 48 or 24 months, which would also be tied into the non-compete of 48 months. And so we think that this kind of meets both of our goals and interests, as well as, given the sensitivity of the technology, kind of makes sure that we are protected in this acquisition as well. But we'd really love to hear your guys' thoughts on this as well.
Yeah, thank you. So we share your excitement to be here. We think the prospect of the deal is really exciting. I want to get to these terms and the agenda you proposed, but first I'm just going to take a step back and talk about how our goals align broadly, and also broadly just what sort of deal we'd be looking for, terms aside. So we see our goal alignment, number one, the acquisition of QSecure technology, incredibly valuable, given quantum security has become a market differentiator. And we've learned that, like you mentioned, our 18-month pilot program. And we understand rival quantum computing companies are looking to enter this space, the exact one that we demonstrated we're capable of during this pilot program. So I think there's three key things I want to talk about. One, the quality of our technology. Clearly, that's our most valuable asset, along with our founder. Two, the certainty we provide, and we think that differentiates us from other sort of acquisitions. I mean, you're already a minority owner. We know each other's companies. You know our technology. And then third, I would just say the market conditions. This is a critical time for your company, understanding that competitors are entering the market and looking to offer this product. So in exchange for all that, we believe QSecure demands a high valuation. And I'd add, again, we've both invested in this relationship already, and we think this lowers our barriers to reaching a deal. In terms of putting all the terms on the board, we don't think it's the most productive way to start, and we're not going to negotiate off of these terms. To be frank, we can't accept a single one of these terms as in our range. And we think it doesn't reflect the relationship that we have. That being said, these terms are out there, so I do feel we have to respond with our own. I'm going to start with valuation, because we think any conversation really needs to start with the amount of money this acquisition would cost. Our offer is $400 million, 80% cash. We think this is a fair valuation given the quality of this technology and, again, our prior relationship. Moving on to payment structure, we're definitely comfortable discussing this early on. We think that's very important. So I understand you've proposed 75% of the payment structure would be an earnout. Is that correct?
Yeah, so essentially it'd be contingent on the milestones that we have proposed, which we find are kind of going to be really critical to this acquisition in terms of both of our success with the technology reaching the market, as well as making sure kind of getting the money's worth. And so the 75% would be contingent on meeting those milestones, but we also want to give you guys the ability to determine that potential, which is why we proposed a kind of split payment structure of an upfront payment and then a contingency.
Sure. So I would just phrase this as you're acquiring 100% of our company. So to only pay 25%, that's not really in our range. So we would propose 10% earnout, which to put in your terms, that would mean 90% upfront, which is far more in line with industry standards. But I totally respect the need to hedge risk and incentivize performance. I think that's very fair. Again, we think the certainty we provide, given our prior relationship, and the fact that this would involve a stock percentage of stock deal, that provides enough incentives. In terms of indemnification, our offer is no indemnification at this point. Through this pilot program, it's been 18 months. We have had no liability come up, and you've looked at our technical roadmaps, but we totally understand, again, the reason to hedge for risk. 18 months isn't a large sample size. 50% is just, that's out of our range. I mean, and far exceeding industry standards, and we think we should actually be below industry standards because, again, you're minority owners in our company. We have this relationship, so we just think that's fair. And then finally, non-competes. Again, our position is no non-compete. This is important for Dr. Cubitt, our founder. She founded this company at a UC Berkeley lab. She needs to feel free to conduct this research, and we actually think that's mutually beneficial, given the tech that can come out of this sort of research. So not unnecessarily burdening us with these other terms, but again, I understand where you're coming from. Would you guys be okay with talking about valuation first, since that's important to us, and we can move payment structure to second? And then we're fine keeping indemnification and non-competes third and fourth, if that works for you.
Yeah, I think the problem is that you say that you're not very risky, but this is actually an incredibly risky transaction that we're contemplating right now. There's alone significant pressure from regulators. We haven't even secured approval on whether this merger can go through. And I think that the terms of valuation and payment structure are related in that way because we would be more willing to pay a higher amount if we could know that we were going to actually gain regulatory approval, have appropriate headcount from the founding engineers of your company. And what was the third one again?
Key employee retention.
Yes. So I think that we can discuss these two things, but we have to realize that they're significantly related to each other, and any change in valuation is going to be reflected in a change in the payout structure.
Totally. Is it okay if we go 1, 2?
Yeah.
Sure.
Let's do
Okay.
that.
Great.
So I guess to start with, I think that we've kind of agreed that we like the structure of having a upfront payment and kind of a contingency payment that looks like what you guys are proposing as well, the 90% and 10%. Do you also see that 10% being contingent on these milestones? Or I'm curious as to kind of when you structure that 10%, how do you see that being paid out? Is there like, would it be on a timeline basis, a kind of achievement basis? I'm just curious as to what your guys' thought was that.
Yeah, absolutely. Judging by the stuff you've said so far, it seems like your incentive behind the payment structures and valuation, we can get to stock stuff in a second, is retaining an employee. So I guess before I answer, I just want to make sure, is this to kind of try and maintain like the whole human capital of QSecure for like a transitional period? Or are you looking to maintain the employees as just part of TitanQ indefinitely? Or are you looking to like maintain the top founders and talents like Dr. Qubit and other core founders?
Yeah, so we definitely want to retain like the key engineers behind the technology. When we acquire QSecure, we're really looking to acquire you guys as like the full potential you have. And so we, of course, don't want to commit to anything by guaranteeing any amount of time for the employees. But we definitely want that potential to be there. And so we think part of the technology are the people behind it. And so we really do value your key founders and engineers behind that. I hope that answers that.
Absolutely. I think given that, what we'd propose for earnout structure is technical milestones based on the performance of QSecure's core technology once it's integrated into TitanQ's stack. The reason I think this addresses both of our interests is it's quite in line of what Dr. Qubit feels is fair in a deal like this, where you're kind of gaining value based on what you can control. And since you just mentioned the most important thing to you is maintaining these core engineers driving the technology, we want to make sure they're put in a spot where their incentives are aligned with what you say is most important to you. So that would be our initial proposal is technical milestones.
I don't think we can do explicitly technical milestones because a huge part of this deal is the regulatory risk involved. So there's no way we can include an earnout that doesn't reflect the fact that it hinges on regulation or regulators approving the deal.
Yeah, so my understanding of the structure of something like this would be that if regulators don't approve the deal falls through, and it doesn't kick into even something like earnouts or payment structures. But if you're contemplating something like a regulatory termination fee or like a break-off fee, we could potentially discuss that under indemnification or valuation if you think that's a concern. I think once we're in the realm of earnouts, the deal's signed, people are starting to work, it makes the most sense to say, hey, we've passed this initial regulatory hurdle. Let's make you earn money based on what you can control. I think that's kind of aligns both of our interests here.
The entire deal would be contingent on regulatory approval.
Well, yeah, I mean, I think obviously there's a lot to discuss there potentially, but as far as earnouts go, these kind of post-deal, maybe 6-month out, 12-month out, 18-month out technical milestones, once we're hitting those, the deal's done, right? And the money's been transferred, remaining earnout payments are beginning to be made.
I think one thing we do want to clarify is that inside of technical milestones, we also see customer adoption, and we just want to confirm that's something that you guys are also considering, is that even if the technology is successful and we are reaching those technical milestones, if we don't have customer adoption, if we don't have contracts on the table, then really the technology is not making money. And so we want to make sure that customer adoption is also being highly considered as part of that earnout in terms of like, we're looking for about 3 to 5 contracts, something within that range. And of course, the details can be ironed out down the road, but we definitely want that to be something that is put into consideration with the technical milestones.
So that totally could be put in consideration. It's gonna depend on these other terms. And I do feel like we're getting in the weeds a little bit where, I mean, we propose 90% upfront. You guys are at 25%. And we're talking about if it's technical or financial, right? So there's a significant gap here still. Are Are you guys able to meet us up at 90% if we're able to put in some sort of financial?
Yeah, that's
No.
definitely not going to be within the range. Like we
Okay.
said, there's like a lot of considerations and there's significant risk, and so having some amount contingent would make Cicely at least feel a lot better about this. And so we definitely can't come up to 90, but is there somewhere kind of in that like lower range that you guys would be willing to look at?
Could we jump? I mean, I thought we agreed to valuation first. Can we jump to valuation?
Sure,
at this
yeah,
point in
we can
time?
go ahead and do that. Kind of on valuation, 400 we think is just a really high valuation. Like we mentioned earlier, we definitely see the potential in this technology. And for the last 18 months, we've been seeing great progress, but it is still very new. And so to take a valuation at 400 is far out of the range for us.
Sure. So, you know, Dr. Cubitt is our client. She believes strongly in this technology. 100 million, that's not an amount she's going to agree to sell her life's work for. And, you know, given our relationship, we're talking to the same clients. We know these top defense contractors, large corporations. This is really hot right now to offer an integrated solution. This is defining quantum. So we think this offer 100 million does not capture how important this could be. I mean, we could make you guys market leaders in quantum computing. As you know, we are already leading the security effort, and an acquisition at this time where you have competitors hot on your heels, we think is extremely valuable. So 400 million, we think is a fair offer. We could come down depending on how the other terms go. And is the cash stock split, is that okay with you? Do you have any opinion about cash stock split, if we could start there?
Why don't we start on the valuation instead of the cash stock split? I think that you say you can make us leaders in quantum computing. We are leaders in quantum computing. Our company is the premier business in quantum computing. You are a technology that would integrate into our stack. It's not something that even is being done in the industry right now. We're trying to move it forward with this. We are a massive company. We have the ability to create this technology in-house. There are other people doing quantum key distribution. We see this as an opportunity with a lot of risk and a lot of potential, but it's not something that is worth $400 million at the moment, to be honest. I think that we would have some wiggle room. We could make an appropriate counteroffer. I think that we would be willing to go up to potentially 150 million.
Yeah, but that would directly tie in, and I know we're not on payment structure yet, but we just want to make it super clear to you guys that we're kind of working on the same mindset, is that our valuation will be hinging on payment structure to a certain extent, and so we do want to kind of make sure that if we are going up in valuation, we are taking that into consideration when we move on next.
I just want to say, I thought I addressed this at the start. These terms collectively are nowhere near where we can accept, which is fine. This relationship is going really well, so we don't have to have a deal. But both 100 million and 75% being withheld, we can't negotiate off that, right? So to get to a level we can accept, we need to both increase valuation and decrease the payment structure.
And I would further add that I think the leverage of developing an alternative in-house would kill your current minority investment in us. And of course, we already have significant contact with the customers you've introduced us to and acquainted us with. So I think that's if this deal doesn't work out, we were hoping the alternative would be maintaining a continued partnership. So I think that threat is mildly concerning. I'm going to assume it's more of just a general alternative. And I would say, based on that not being a super plausible threat, and based on the fact you do have minority ownership in us right now, it doesn't make much sense to do a valuation, which is frankly, which is way below what the market would value us at, even at our current minority stake.
As we told you in our last negotiation when we planned this agreement of the last 18 months, we view our investment in QSecure as an investment in technology, not as an investment in QSecure as a standalone entity. We see you as something that can be integrated into our tech stack and something that can improve our product as a whole. We are a integrated quantum computing company that are offering this quantum security layer on top of it. You have our contacts, the Department of Defense. We do too. But you are offering quantum security, we're offering quantum computing, and that's the bulk of the product. This is just an authentication layer.
I think to maybe get out of this bit of circular position here, I guess I'll just ask you guys. Our client can't go anywhere near this payment structure evaluation term even if we get our exact terms on everything else. That's just a non-starter. So what do you think, like, how we want to make a deal here, work with us. What can we do or what can you do for us to work out?
We're willing to do $150 million in valuation.
With 25% upfront, like that's just nowhere near what's acceptable.
Why don't you give us a counter offer?
Right.
If we lower the cash percentage, can you go higher than that? Because 150 is still too short for us. Could you go up to we could go down to 350 and reduce it to 70-30?
So for us, the cash stock would not be codependent on the valuation. And so we're happy to consider the cash stock split if that's important to you guys. We're willing to kind of work on that. But in order for us to kind of move the conversation along, 350 is still out of the range considering the concerns we have with regulatory approval potentials as well as scalability. We're just not seeing that yet, which of course, because this is such new technology, that's completely reasonable. And so we do want to make sure that like all of that is being considered. We could potentially go up to 200, but that's kind of around the range that we're looking at.
Can I ask again about, so regulatory approval, if this deal gets shot down by regulators, you're of course not on the hook for this payment.
Right. It's not just the initial regulatory approval. Of course, as the technology advances, different approval issues might come up, compliance issues can come up within regulatory. And so even though we might get initial approval from regulatory part of like authorities, we are still looking at a long-term kind of issue. And so as technology develops, as integration continues, we might run into kind of other issues that might rise. And so those are the concerns that we're looking at. Of course, like you mentioned, immediate cut, then everything falls through. But
Right.
kind of moving aside from that initial aspect is
I think
kind
that's
of
a fantastic point. And since we're not, at least in valuation, this earnouts we can get back to, but since we're, 200 million, 350, we're not too far apart. And that does start to bring us into indemnity, like
Exactly.
forward-looking regulatory versus commercial. Might be good to move into discussing indemnity now. So
Okay,
could you guys kind of, the introduction I got that your idea of indemnity is you want to make sure that with the risk you're taking by acquiring us, you're not, selling your own company short. I guess my question is, why not allow us to remain, or why not encourage us to remain an independent partner if you're this concerned that 50% of the deal might go bad?
It's more the way we see it, the indemnity issue is kind of just making sure that the risks are being balanced between both parties. Yeah.
Yeah, it's really just a matter of risk. Like, this is a business that is inherently risky. We have great hopes for your business, for our businesses together, but of course, we would not be meeting our fiduciary responsibilities if we did not consider the potential downsides.
Sure, but you are taking on the rewards. You're buying our company, and you're absolutely right about you guys being a market leader, but we understand, this is a serious-based competition currently. So we think we can cement you as a market leader. 50% in 24 months is too high, and again, given our prior relationship, we think it doesn't show a lot of faith, right? This 18-month pilot, access to our technical roadmaps, but some sort of hedging for risk, I think is totally reasonable. We're willing to go up to 10% of deal value for a 6-month survival period, and we also are concerned about regulatory risks. So we would want regulatory indemnification excluded on the basis of we are currently in compliance with regulations, and we can't really control the regulatory regime. So if standards raise, that's something we don't think we should be liable for, again, because you're taking the reward here. So that's our position for indemnification. Yeah.
We completely understand wanting to make sure that, like you said, we are acquiring. And so with acquisition, of course, that comes with acquiring some of the risks, of course. And so 10%, we just don't think is, honestly, to be frank, quite fair yet. And so we are looking at a little bit more indemnity protection there for a little bit of a longer time period. But we could be willing to come down to like 40% indemnity for maybe 20 months or something within that range. I mean, I know that still puts a pretty big gap, but I think in order to kind of move things along, we should maybe look at some more balanced terms.
Yeah, absolutely. I think the problem for us right now is the way we see our current partnership. If something goes horribly wrong on the regulatory front, we're going to be kind of bearing those losses equally. So like we don't really see how we're selling our company to maintain the status quo of the amount of risk we're bearing while you're now getting the upsides. I think that's why this is such a tough issue for us. And it's just if I can finish real quick, sorry. And our client is very concerned about kind of having a fair distribution of risk here. which we understand your emphasis on regulatory, but our client Dr. Qubit simply doesn't think it's fair that these regulatory changes in an evolving landscape after a deal could be retroactively used to punish her and her other founders and investors when they're in compliance right now. I mean, we're definitely willing to move in this number, but not up to 40%.
You're talking about it's not going to change your risk profile. It will change your risk profile because you're going to be taking $75 million in cash right away. That's not going to be subject to any sort of anything. Your client will have made a lot of money off of her cryptograph or her quantum key distribution technology. But what you're selling us is the future. You're not selling us like a product that has obvious intrinsic value. You're selling us potential. And so what happens in the future is, of course, extremely relevant to its current valuation. And that's why we want to tie in the amount of risk of future regulatory changes into the price we pay.
I hear you 100%, and I want to make sure that we're really acknowledging this. It seems to me like you're kind of oscillating between concerns about the technology not being adopted and regulators changing standards. So I want to make sure, no, I think those are both entirely legitimate concerns, and I want to make sure we're addressing both of those. I think I can definitely agree that the total valuation should reflect the fact that regulators might blow this deal up, there might be changing issues. And when it comes to indemnification, we're willing to assume even more risk for what ends up happening regarding the technology. We could go up to 15% with a 12-month period, because I think it's the same thing my client cares so much about, which is basically having a fair distribution of risk here based on what people are actually responsible for. I would agree it actually is even fair for us to bear a little more of that technological risk, so long as we're excluding the regulatory side. So can you come down towards that, or?
I just want to add one thing too. The risk for us here, our client believes the valuation of our company could materially increase 24 to 36 months from now. Obviously, we're comfortable hedging risks at a certain price, but this level of indemnification we're not comfortable with. And we understand competitors are looking for quantum security. That's what we do best. We're market leaders in that space. We have a significant opportunity. We feel to give that to you, this level of indemnification just doesn't reflect what we're giving up.
Yeah, we completely understand your concerns with that. I am curious, so we know that one of the concerns for your key founders is kind of reputation as well as kind of their position in this company going forward post-acquisition. And so I'm curious as to how you guys seeing that tie into indemnification, because you did mention kind of you're giving up this technology, but we are also taking on a lot of your key founders who will be continuing this technology. And so kind of that risk does continue, as though right now we are in a very, very promising position, but we don't know where that's going to go down the line. And it's not like we're completely replacing all the employees and starting fresh. And so kind of that risk is still being split between our two companies, because we see a company not just kind of as QSecure, but its founders, its engineers, kind of all of that as one. And so we are taking all of that on when we acquire you guys. So I'm curious as to where you guys see yourself in that position.
Yeah, just to make sure I'm hearing you correctly, what you're saying is because many of our senior leadership will be retaining some sort of operational engagement, that it would be more fair for us to bear some of the risk, because they will be responsible for.
Right.
Yeah, I absolutely hear you on that. I mean, this does start to get into something we wanted to discuss under non-compete, which I'm concerned moving on to that because we still have such wide gaps in the other three terms. I fear moving on to a new term now will just mean we're left with 4 terms we're far apart instead of maybe 1 or 2 we're close.
I'm happy to kind of loop back up to payment structure maybe, if we want to try to bridge that gap a little more.
I think that's a great idea. Can we just hear where you're at for indemnification? Our latest offer is 15%, 12 months.
I think we can come down to maybe 35% onto the indemnity. I think 20 months though, we do want to have some kind of protection period there. 6 months is, 12 months is still a little short for us, especially because we've had 18 months so far. And so kind of going down to just another 12 months of indemnity.
Yeah.
I can go ahead and
I hear you.
this, though.
35%, that's still out of our range. And, you know, it's outside of industry practice as well. I mean, we typically see 10 to 20%, and that's with companies that don't own a minority share, right, and didn't have this sort of pilot program. We could go up our absolute highest, we could go 20%. But for that, we would need to lock you in at $350 million, and we're comfortable with The cash stock split, it doesn't sound like that's too important to you, but if you have any suggestions, we can change that as well. So we could go 20% at a 350 million valuation.
When you say the 20%, what month range are you looking at? Because like I said, 1 year is just too short for us on that end.
I think we could meet you in the middle, again, subject to the valuation, if we go to 18 months. And if we do that, again, we have to exclude regulatory indemnification, but I think that sounds like that's in line. I mean, we would be subject to any sort of tort liability. This is just if the standards raise, and that's a responsibility we think we shouldn't bear.
I think
20% for 18 months.
20%, 18 months at a $350 million valuation.
so. I think,
just
right
not
where we get
happening.
stuck. I think the 20% for 18 months is something we can consider, but the valuation would need to go down then. For 350 is just not within the range that we see. Kind of, again, like we said, there is high potential here, but we don't think that 350 kind of accounts for our other concerns that we have.
At that level, I'm just curious, what sort of valuation could you agree to, given we've come up 15%, 20% if we agree to this on indemnification?
50% on our valuation. You've only come down 50 million out of your 400.
The initial valuation was.
I think we both moved 50. I think that's kind of an odd framing. What I would say is I do feel like we might be getting stuck again. Let's look at payment structure, because even if we agree to valuation right now, when we're this far apart on earnouts, it's basically meaningless. We're talking about different numbers of cash that's going to be in hand of our core stakeholders soon. And even for you, it's a massive difference in how much of your liquid capital you'll have to deploy. So I think our best bet might be, look, as a gesture, we'll go down to 80% upfront, because I think, especially if we're not lifting this indemnity, we're keeping this valuation in this range, we could do a 20% earnout, I think, as long as it's based on technical milestones.
And we'll just add a 12-month term there as well.
The way installments are done is you can have your free reign with that. Yeah.
No
Yeah,
way.
and our justification here, again, is we feel we've proven the technology in this partnership, the competitive pressures. And I know stock split was not, it seems like you could go either way on that. We do propose a deal that does have a significant stock split, and we think that provides significant incentives in terms of earnouts. The more stock, the less need for an earnout. Our employees are already in line with your best
Yeah,
interest.
I was wondering if you might be able to explain that a little more to me in terms of the stock versus the incentive. Because the way we see it, the stock is still money in hand for you guys, right? And so I'm just curious as to how you see that exactly tying in with the earnout.
Yeah, we see that tying in terms of our own employees' incentives. I know you mentioned the technology, but obviously this comes with our employees, right? Dr. Cubitt is the foremost expert in this space. And we think this provides powerful incentives for her to perform well for your company, which increases the rate of success, lowers the need for an earnout. That's above industry standards for us.
Yeah. So again, like the terms we see, while closer to what we might be able to kind of come to, are still outside of the range that Cicely and TitanQ would be comfortable with. We could look at a more like maybe 30% upfront, or 30% upfront. Leaving with maybe 70% contingent, again, on those key milestones, the technical ones, as well as customer adoption. And just so that we're kind of moving the conversation along, we'll also be willing to increase valuation up to 200 million, because you did ask what would be closer for that indemnity agreement. And so for us to be comfortable, that would put us at about 200 and then 30 upfront.
Could I ask, is there any situation at all where your clients be comfortable with like 50% or more upfront ever?
Not over 50%.
So there's no, is that, just to be absolutely clear, your client would never be comfortable
to be completely
more
frank
than
with you
50%,
and fully honest, because we respect this relationship a lot. 50% would not be something that would happen.
Okay. I hate to say it, but I think the prospect of a deal is tough. I mean, because our client is not willing to even accept 50% upfront. We would need more upfront than that. Can I ask what your reservations are with the upfront payment, just given our prior relationship?
Sorry, I want to clarify. We're talking about the 50. Oh, yeah. Thank you. No worries.
Versus the earnout percentage is reciprocal, and that's the confusion.
Oh, yes. Okay.
Right. So our offer is 80% upfront.
Okay, and 20% being the contingent.
Right.
And so.
Which is not
And
something
you-
that we can do.
You said 50% upfront, 50% contingent would be like what you guys.
No,
or
that's
the
purely
maximum.
hypothetical.
Okay, I see.
Yeah.
Yeah.
Okay, so maybe because I think this might be an area then where there's such a gap between what our clients are currently considering, it might not be productive to discuss it more since we're just not going to be able to reach an agreement. Let's try to discuss non-compete a little bit since we only have about 8 minutes left, and that way we can at least see where we are, bring something to our clients to maybe reoffer. Yeah.
Yeah, do you guys want to start and tell us what your concerns are with the non-compete agreement?
Yeah, we don't. Well, this company that you're offering, it's mostly expertise. It's Dr. Qubit. It's your founding engineers. It's their support going forward. It's their understanding of the state of their technology. If we purchase this company, especially at such a large valuation, and then lose talent, then it's possible that our investment will just not be worth what we predict, and that's why we need to protect the talent that we purchase.
Totally, yeah. And if I can just draw back, I think the stock split does address this, but we can understand the need, especially at a higher valuation, we could move on non-compete. Our consideration is we do have to worry about Dr. Qubit, but we have other stakeholders as well, our other employees. We would just need some sort of commitment because this is harming them economically, let's say if they're terminated, not for cause. So could you provide some sort of assurance, an agreement that the non-compete, say, terminates if an employee is terminated not for cause?
If an employee is terminated not for cause, then they're able to compete?
Yeah, then their non-compete would no longer apply to them is what we would ask for. We think that's only fair.
I don't see why we're going to do that.
If someone's put out of work, we just need to protect our employees if we're going to agree to a deal.
That's a natural thing, and we're not trying to crush your company.
We never want to put you guys in a position that would be
Yeah.
completely unfair, especially
great.
with how much we value the key founders and the key employees. Yeah, we'd be willing for that.
Okay, so, all right, as long as we can agree to that term, we can go up on non-compete. We could go up to 12 months, but we'd want to limit this to direct competitors. And I think with the other terms in this deal, like indemnification, I think it goes well with that term, right? Like after a year, that is a sufficient amount of time to assess the deal and to seize this opportunity where we think, I mean, listen, our employees love this company. We don't think there's any desire to jump ship, especially given this incentive structure. We think 12 months addresses that and gives you guys time to really seize this market opportunity.
Yeah, 12 months is a little low for us. We're willing to also kind of look at a split between a certain amount of months for direct competitors versus adjacent platforms. And so if that's something you guys might be open to, we could kind of maybe look at 36 months for direct competitors and 24 for adjacent platforms, if that's something that we can like potentially split out too.
Yeah. I think that's a great distinction. Our offer for 12 months was just for direct competitors. So we would feel comfortable keeping that, and then we could maybe add an additional length of time for indirect competitors. Our main concern is we just would not want that to address university research.
Okay.
So yeah, could you just give me some idea of what like an indirect competitor would be? Would that implicate research?
Indirect competitor, you mean adjacent platforms?
Adjacent platforms. Yeah.
Adjacent platforms.
Okay, so other corporate quantum applications that aren't necessarily in this, like your biggest computing competitors.
Yeah.
Right.
I think that at least that split between direct and indirect, we're big fans of that. I think that hits both of our interests. So we're 100% good with that split. The exact terms to shake them out a little bit more. I think we could definitely be willing to go up to a 18-month non-compete for direct competitors and a 12-month and a 6-month non-compete for indirect competitors.
For 18, we would see that closer to being appropriate for the adjacent platforms, considering kind of the competitive interest. And so we can see 18 here in adjacent platforms, but we would need the direct to be a little bit higher than 18. Is there any number kind of within that range that you guys see for direct competitors that would be appropriate and make your client feel secure as well?
Yeah, I mean, just given the time here, I think we could, our client's interest, we could go to 24 months, which is our absolute highest, and that's limited to direct competitors. But for that limit, we're gonna need $350 million. We would be comfortable locking that in. I mean, we're giving up a lot for non-compete. Would that work for you?
We can do 300 at 24 for direct competitors, but that would be our cap.
We would need a little more than 300. I think we could do 325, but it would have to, and we could also drop. We could go 60% cash, 40% stock.
Would you look at 300 for a change in the upfront, potentially to a, let's say, 60% upfront if we were to make that jump? But 300 would be the max we would go on that.
It was my understanding from representation earlier, you absolutely could not go above 50% up front. So is that...
That was my mistake.
Okay, no
and
worries.
I'm so
No
sorry about
no worries,
that.
it's totally
I was
fine.
looking
yeah.
at the contingency. That was completely on my end.
Okay.
Did not mean to blindside you with that, guys, at all. I'm so sorry.
No worries at all. No,
But
no.
In order to kind of move the conversation, would that be within your range?
60% upfront, not in our range.
Okay.
That's still a bit short.
What I think we could kind of, since we're coming up low on time,
Right.
tentatively agree to that. Something in the range of like 60 to 80%. It's definitely got to be well above 60. But in that ballpark with, I think, 325 million, maybe meet in the middle of those values. And then the 24 months for direct competitors and 6 months indirect. Those three terms together, I think we could work with broadly.
You threw a lot of numbers real
Absolutely,
fast at me.
yeah.
I'm gonna need you to,
Yeah.
you could slow that really fast down for me.
70% upfront. We would need the
Okay.
valuation to increase to, we were at 300, so to go to 325. And then the other terms we're comfortable with.
You go 24 months here.
24
for your
months.
request. And stay at 6 for indirect.
We can do the 24 for direct. That's something we're okay with. The valuation is still something we're gonna have to take back to our client for that one.
Absolutely. Yeah.
But we can lock in the 70% upfront, I think.
At 325 million?
What?
It really hinges on the valuation for us to agree to some
Yeah,
number
so
like
the
that.
valuation we're gonna have to take, we can do a tentative, but the valuation we're gonna have to take back to our client.
Okay, those offers also hinge on the valuation, but it sounds like we
Yes.
have some sort of structure here.
I think so, yeah.
Yeah.
And I think that this definitely,
made some
honestly,
improvements.
from where we've come, we see this being a great progress. We've really enjoyed working with you guys for 18 months, and I think that we formed such a great relationship that we're able to move this along. We're really looking forward to continuing this conversation once we talk to our clients.
Yeah,
Us as well. Thank you so much.
yeah, thank you guys.
Thank you.
Hey everyone, we're gonna get started again. We have Cameron and Kausar going to present their post-negotiation analysis.
So I think that went pretty reasonably well, honestly. I think that it can feel a little bit striking at the beginning of a negotiation when we're just so far apart on all of our terms, but that's kind of the nature of the game that we're playing. They want to ask for too much, we want to ask for too little, and we're going to meet somewhere in the middle. I think that we went back and forth a lot on all of the terms, but ultimately we did pretty well on the terms that weren't valuation, and we didn't end up agreeing to valuation. They were asking for too much money. We weren't willing to pay that. And on that basis, I think we got some concessions in other areas. We were close to our target in payment structure, indemnity. The non-compete, I believe that it ended up being within our target, but what I think we should have done in retrospect is when they asked for these initial things at the beginning, like, can we do academia? You're not gonna fire our employees, right? We initially took that as a given. Of course, we're not gonna fire your employees, but that was never something we were thinking about. But in retrospect, what we should have done was act as if we wanted to and try and get concessions from them in other areas for that.
Yeah, one thing that we think that we did well was trying to dig into what was important to them. And so I think that when it came to the cash and stock, while it wasn't a huge value to us, I did try to ask and fees out kind of what the stock really meant to them, how it tied to their incentives, how it tied to earnout potential, in order to kind of gain a perspective to why it was important to them that that was on the table. Same with the non-compete, because we knew that their employees were concerned about their position in the company afterwards. We tried to kind of use questions to pierce out why the non-compete was kind of going back and forth so much. And I think that really did help us because we were able to get a lot of concessions on the non-compete. 24 months was our kind of high, not our low. And so to be able to agree at 24 months for direct competitors, we felt was a really good prospect for our client. And I think we achieved that through finding out that it might not have been their highest concern. And so that was something that we incorporated from prior rounds, is trying to see what was important to them.
Yeah. Yeah, I think the valuation was just the one thing that we just were so far apart on. That was going to be tough to reach a deal on. We couldn't have paid $325 million. Do the judges have any questions for us?
I guess on that end, we also kind of, one thing that we really wanted to acknowledge was that we felt it was okay to leave terms on the table. And that was something that we took both from feedback from prior rounds, was that you don't always have to reach the agreement in 40 minutes. And so leaving indemnity and kind of valuation to be taken back was something that we felt was important, so that we didn't rush into an agreement that wasn't favorable to us. And so while we do think we might have been able to come a little bit more in the middle, to kind of leave that on the table was something that we were comfortable with and we felt supported our interests better, especially since we had come from so far apart to such a middle ground area that we really appreciated that both parties were able to move the conversation along. And I think that's something that we appreciate about our opponents as well, is being willing to move the conversation along when it seemed we were getting bogged down in certain areas. And so to kind of be like, okay, maybe it's time to circle back or move to a new topic. We really did try to do that as well. Yeah,
I was also surprised we didn't discuss the nature of the earnout. I think that that's a very essential term because that's essentially what their money is contingent on. There's a lot of rhetoric back and forth about risk allocation, which I think was kind of like the heart of this case. They were saying that they're still going to be exposed to risk. I was saying otherwise. I think that that's kind of where we got bogged down in indemnity, and potentially was more about kind of the background facts of the case as opposed to our negotiation positions.
And kind of one other thing about our thinking process coming in was something we really like to do is kind of come up with creative, like, middle grounds and solutions. And one area we really found that to shine in this fact pattern was the kind of split between adjacent platform and direct competitors. We felt that because those are two very separate things, having a direct competitor versus an adjacent platform that might use your technology, we felt that it was appropriate to kind of split that, and it seemed that they were very agreeable to that. And so even though we didn't reach complete agreement on the adjacent platforms, that is something we tried to incorporate, was kind of having some creative middle grounds that kind of broaden the pie, in a sense, for both parties to be a little bit more willing to concede on certain aspects. And that, I think, is time for us.
Perfect.
Thank you.
Thank you so much.
You leave the room?
I think we get out again.
Would you prefer we address the judges or the audience? Should we address you guys, I'm assuming? Okay, perfect, perfect, yeah. Stand like here. All right, cool. We'll do about try to do around 4 or less minutes of eval and save a lot of time for questions. So unfortunately, we think this was kind of a messy round, and we think a lot of the fault with that lies on us. We think both laying out initial offers just simply isn't a great way to have a conversation, because it leads to both parties kind of just being like, we've moved farther from our initial. No, we've moved farther. Which happened with valuation, where we felt it was unfair when they're like, well, we moved up 50%. It's like, okay, we've both moved 50 million. That just incentivizes your initial offer to be $1, right? But we frankly didn't know how to address that beyond kind of matching the strategy so we could have a similar deal posture. So we think this was maybe an okay way to handle it, but still made it messy overall. Second point, the confusion on the earnout. We take partial responsibility because we were kind of stunned to hear they couldn't go above 50%. This felt way outside of the realm of what the general facts, which we knew we both read, contemplated, and way outside of industry standards. So we tried to pry at that, and I think a little more aggressively, and it was way too late before we really were like, all right, are you sure it's above 50%? And I think if we get that out there sooner, things go way better. And then finally, I think we kind of failed to make it collaborative. I tried at some points to ask, and Cole especially did a very good job trying to kind of lay out our goals around, which he also stated very clearly at the beginning, saying, look, we want a fair deal. We want to make sure that our stakeholders have options for other jobs. And we tried to pull them in and say, hey, how do we address those deals with those goals of a deal that serves both of us? And perhaps, again, because of some of the confusion of the earnout, we were still so far apart in issues that laying out goals didn't really move us to the middle. It just led to no counteroffers. And we felt like we really had to drive the conversation regarding counteroffers, which also wasn't the most productive because we can't just unilaterally go, you know what, we'll go down 50 million in valuation. That's in bad faith to our client. And if we're getting nothing in return isn't a productive way to negotiate. So as far as the terms, I want to say, I think what we're most happy about is getting near the top end of our valuation, even for this prospectively agreed to range. It's something between 300 and 350. Even if it lands at 300 at a 70-30 cash stock split, that is a windfall for our early shareholders. So we think even if we get near unfavorable terms and everything else, they'll be quite happy. On earnouts, it's hard to talk about this one too much, I think, because of how confusing it was during the round. I think I realized they might have had it backwards very late. Even though I tried to be very clear with the whiteboarding of upfront versus earnout, I just didn't get through. Which, if we had clarified that sooner, once they came up to 60%, it felt like dominoes started falling in place. And we almost could have reached a deal if we had 2 more minutes, which is so regrettable. Because if we had really kind of ironed that out, made sure we're on the same page at the start, things might have gone better. But once they're at 60%, we were at around 80, 70, something in that ballpark. As long as we could have landed in the middle at 70, that would have been near the low range. We got technical milestones, would have been okay with us, especially at the high valuation. Indemnification, we were basically at the bottom range of this. We didn't really get clarity in excluding regulatory indemnification. And that would have been a must-have for us. So we think that's something in a future negotiation we're going to make very clear. And hopefully with more flexibility on payment structure, we can also be more flexible on that term. And finally, on non-compete, we think this was also a little messy, but we're relatively happy to have this non-direct competitors thing. We would have liked a little more clarification on indirect, and I tried to ask for that during the round, but I think since I knew we weren't going to reach a deal in this time frame, there was no point to spend our precious last 2 minutes being like, well, what exactly is an indirect competitor? I figured we can table that for the next round. We have a general framework here.
Yeah, so I would just add, we did not agree really to a single term, but once we got in this structure where they weren't moving on earnouts, and I mean, just to be clear, 70%, we can't accept any lower than that. So it would have been impossible if 50% was their lowest. But again, we think we could have called that out more clearly. But it would be a big win for our client to accept these terms at $325 million. So once it got to the point where it was clear they're not willing to move past our worst case for these other terms, our advocacy turned to, okay, you have to pay for that. Which they would be thrilled with 70% upfront at $325 million. That's close to our best case. So it was just understanding what's most important to them. And another thing we tried to do was focus on the relationship. Like some of these terms, like indemnification at 40%. I'm not an expert, but I haven't heard of that in most deals. My understanding is that's far above standards, and particularly given they already know our company. So I just tried to make that clear. So I think we were able to advocate for our client and adjust, but we thought it was a great negotiation overall, despite the challenges. We have 30 seconds for questions if you have anything. Okay,
cool.
Great.
I'll use the last 20 seconds here to just kind of emphasize a key point that the reason we're so happy with a high valuation, even at the detriment of other terms, is because it may be kind of boggle the mind that a company like this, which has one real core piece of IP, can actually have such a large upside. But at the end of the day, Dr. Cubitt, who is the expert in this field, believed that. And we believe our clients, so we have to take this high valuation and make that our strategy. And we think that's why we had a solid approach. So thank you.
Thank you.
You guys, right?
All right, well done to everyone. And I'll try to be as quick as I can. First of all, just in general for everyone, very complicated cases with a ridiculously short amount of time. So always very impressive to see how professional everyone is, how polished everyone is, how well everybody keeps track of all the different things going on at the table. It's impressive. And I just think a good job to everybody there. So for me to give some feedback that will help you for next time, I think the thing that defined the negotiation for me, as we've talked about a little bit, was in the first few minutes of the negotiation. And so I want to talk about starting an opening statement with an offer and why some of the things that suffer sometimes when you do that, and then how to adjust to it. Because I think there's a question that you said in your self-analysis. What do we do to adjust a situation like that? So for the opening statement, I think your opening statement was very crisp and clear and very good. And the reason not to put an offer on the table quite so quickly, in general, if you're to do this again, is because it doesn't put you in the best possible position to make the case for your anchor points that you're trying to make, right? So it's very predictable. Everybody had a lot of consternation around the idea that the numbers were really far apart. That's actually fine. The numbers are probably going to be far apart. That should be your expectation to some extent. So really, the value of that first offer is to get some of your thinking on the table, some of the principles that'll be guiding your later decisions on the table, and then also to see how the other side reacts and get listen to them while they're giving pushback in different places. But you also want to be able to have a little bit of back and forth and context setting so that you can make, when I put the offer on the table, I can start to make a case for why this argument makes the most sense. And what happens when you put it up there too early is you just talk about all the reasons it works for you, which is great. That's information for them, but it's not very persuasive towards, it's not you're putting your best foot forward in terms of being persuasive about why do we think that this actually has a chance to work for everyone, right? And so for the second team, I already forget the company names, but for Cole and Jack, your opening statement was quite good on that particular front. But in what you said in your self-analysis, how do we adjust if there's an offer on the table? I would say the only thing that you want to do if the offer's on the table, because it's not that the game's not over, is to just ask them why, right? Go piece by piece and point by point and say, let me get some of the thinking that you have behind these, because you're never going to take their first number by definition almost, right? So what's important is to say, let me understand how you think that this works and what things are your priority orders, which things are most important to you, which things are least important, and engage with them in a dialogue about that piece so that you can get that information, so that you can use that information when you put up your first number, right? Because what we started to do is to get to a little bit of people putting numbers on the table, the numbers don't work, and then we say our answer is it's too much, right? And we heard a lot of that number's too much. Can you make it lower? That number's too much. Can you make it lower, right? And we're a little bit better positioned to be persuasive if we have a little sense of how they're thinking. Do these numbers in aggregate represent a balance that makes sense that we're looking for, right? Those kinds of things. And in order to get to that kind of stuff, you actually have to put some of the principles out on the table first, and you have to do a little bit of context setting before you get to the opening offers and counter offers. So that's what I would do, is not be so worried about the logistics and be a little bit more focused on getting the general principles or sort of criteria you'll be using and thinking with on the table a little bit quicker.
Great work. I'm going to come from a vastly different perspective, as I probably will relate more to the QSecure and TitanQ founders that you're representing and the owners of the company from a practice perspective. So it's really delightful to see both teams go at it with such commitment and conviction, and you all comported yourself excellent. So great work, everyone. It was a delight to witness that. Reading the entire experience and negotiation, I think there was probably in far less technical terms than Clint just used here. That was one of the things in the early part of this that I observed in the exchange that might help you, is kind of reading what each side prioritizes for the negotiation. Taking a beat to read that, leveraging individual teamwork on your teams to kind of say who's going to be able to listen, who's going to be able to pivot, I think would definitely have probably led into a different framework than just moving on individual numbers. But I think the teamwork exhibited, you guys did great because you helped each side, each of you on each of your teams move to that direction. Similarly, I think there's the other side of negotiating, and that's when you're building on a win. And at first, I think when you folks all found a collective groove, you eventually got to that, building on a win. What can we agree on? What can we double down on? And use that to get momentum. And so you use that really well. I'd say look for that earlier to build on a win, to work as a collective group that's working on it. And I think that's really the gist of it. Really proud to see you guys doing this, and maybe when you graduate, let's talk. But thanks.
Yeah. So first, I just want to say congratulations. I think you guys all did so well, and I think that I didn't sign up for anything like this when I was a 1L, so that in itself is just something to be very proud of. I think my sort of one constructive point is I understand the laying all the terms out and sort of trying to hit them separately, but realistically, all these terms are so interconnected, and you kind of can't look at valuation in a vacuum or look at, how things are going to be paid in a vacuum. I think, there's lesser important points like non-compete or, indemnity, but they are all tied together. And so I think, I understand you need to get through everything, but that is something in a negotiation where they all are very interdependent. And so it's sort of like a package, and you can move different levers within that package, but I don't know that they can be fully divorced from each other. But I think sort of in the second half of the negotiation, you guys found your groove. And I really appreciated that each side was trying to drill down and figure out, why is this important to you? What does this actually mean for your founder, for your client? And I also really appreciated when you guys moved things forward and weren't, just decided a stalemate was not going to work, and you both came forward with productive counteroffers and a willingness and the spirit of negotiation and to move forward. But yeah, I think everyone did a great job, and I hope you feel really proud of yourself, because we're proud of you.
Yeah, like everybody said up here, y'all are definitely an impressive group. So very amazed at your skills, and might have some takeaways for my own negotiation style. I think what I'll say is, when you're in this kind of time constraint situation, I think it's easy to get very like, oh, we have to keep moving. But you have to remember you can also take time to like step back, confer with each other, make sure you're realigning. And also when you're working against each other, such as with the like kind of earn out confusion, you can also take time to be like, pause, wait a minute, are we on the same page? Are we saying the same thing? Is there confusion that we perhaps just need to clear up? So then we can move forward through the negotiation. And I will say I definitely appreciated the Titan team's like creative thinking with the non-compete split. So kudos to y'all. And yeah, overall, thought y'all did an amazing job.
Thanks so much for the feedback. And the winners of the final round are Cole and Jack for QSecure. Thanks again, everyone, for coming, and to our judges. Have a great rest of your day.